I have Debra Crane with us answering legal questions about family law, and we're going to go right to the phones and talk to Dan. Dan, you're on the Law Show.
My question relates to participants in a divorce case of inheritance received by one of those participants between the filing date and the finalization date of the divorce. Is that included or excluded in the assets considered in the divorce?
Dan, is it Dan or Don? Dan.
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 Okay, Dan, I'm glad you called. It's not exactly cut and dry. For the most part, inheritance is not included as a marital asset unless there are not enough assets in the estate to leave both parties with a fairly decent life going forward. Generally, it's not, but it's not set in stone.
So, Dan, tell us a little bit about this inheritance. What is the type of inheritance? Is it a lot of money? Is it property? What is it?
It's property.
Okay. So, Deborah, is it going to be as easy to divide up property as it might be, say, an inheritance of cash?
Well, it doesn't exactly matter, but property, of course, might be easier because it'll be titled a certain way, and I don't know, how did you receive it from a trust, or, how did you receive the property?
Well, I haven't received it yet. The property is in a trust.
Okay, and will it go to just you, or you and siblings?
Just me.
Okay. Well, do you have an attorney helping you in your divorce?
Yes.
And what did your attorney tell you about this circumstance?
He said it's not includable.
Okay. Well, that gives you a real good bird's eye view that you can talk to two lawyers and get at least two different opinions on every single issue. So, listen, we're really glad.
I'm an ex-CPA. I'm an ex-CPA, so I'm doubly careful.
You should be careful. It's always best to get a second opinion. That's what you did by calling the Law Show. If we can be of any other assistance to you, just let us know. And we're glad that you have a lawyer and somebody that you feel confident about, because it's really, really important, isn't it, Deborah?
It is.
Thanks for calling the Law Show, Dan.
Thank you very much.
We're going to continue answering all your legal questions at 855-529-7469. That's 855-LAW Show. We're going to talk to Jim. Jim, you're at the Law Show.
Hi. My question is concerning a battery or an order of protection case where I was a victim. I had to hire an attorney to represent me to work me through the process and to get my order protection and battery case completed. Do I have any recourse in suing the defendant to recoup my attorney fees?
Now, explain this to me again. What happened to you?
I was a victim of an attack.
Okay.
And so I filed an order of protection, and there's also a subsequent battery case. I had to hire an attorney to represent me to work through the issues of the order of protection filing and other issues related to that. So I'm just wondering, is there any recourse in suing the defendant and getting my attorney fees back?
Well, the general rule in America is that you don't get to sue for attorney's fees unless there is some statute that allows you to do that, okay? I'm not aware of a statute in this case that would allow you to do that. However, it seems to me that that you may have a claim against the other party for the assault itself, right? So is this other party, do they have money?
I believe so.
Okay. So you have an assault and battery case, which is what's called a tort, and you can file that tort against this individual and try to make them pay you whatever your damages are. And I don't think you'll be able to get the attorney's fees, but it's possible. It's something worth looking at. Have you spoken with a lawyer about this yet? I mean, other than us.
But I haven't talked to a lawyer. I haven't talked to an attorney or a lawyer about the attorney fees that I had to pay out.
But do you have a lawyer suing for the assault itself?
Yes.
All right. You should talk to your lawyer about that and see what he says. Listen,
okay.
We love it when clients call us and they've already got lawyers, but you really should, out of respect to your current lawyer, you should contact them first and find out what they say. And if you want a second opinion, call us too. We'll give you a second opinion. We'll even sit down and review your entire file with you and tell you what we think without even calling your lawyer that you have now, so we don't cause any trouble in that way. Just call us at 855-529-7469 if you've got a legal question at any time at all. Especially now during our show, it's the Law Show on 89 WLS from high atop the Law Show studios in the Windy City, Chicago. We broadcast every single Saturday at 10 a.m., and we'll continue doing so. If you are on the air when we go off the air, or if you're on hold when we go off the air on WLS, stay on the line and we'll answer your questions. I've got Debra Crane here answering questions about family law, and we're available right now. I am answering questions about everything else, including my area, injury law. Please call me at 855-529-7469. We're going to go back to the phones, and we're going to talk to Bill. Bill, you're on the Law Show.
Hi, how are you doing? Thank you for accepting my call.
Good.
Back in May, I purchased an investment property, and about a week later, I was visited by an inspector from the City of Chicago's Department of Sanitation. I got a letter on September 5th that according to this inspector, our grass was 10 inches tall, and therefore we need to pay a $600 fine for that. Now, first I see that as kind of excessive. The other issue I have is that they gave us a week to respond, and the court date to appeal is 3 weeks from now. And according to the notice, if we don't respond in a week, then the fine can double. I'm not certain, first, whether this is a legitimate claim they have, but secondly, whether, really how to respond to it. We don't want to pay it. We want to go to court to appeal the decision, but I don't see any indication in the notice about how to give you the notice that we're going to court. So from what they would see of it, we would have been, out of compliance because we didn't respond to it. So.
Right. Listen, if you can scan and email the notice to me that you got, I'll get back with you. When do you have to respond? By Monday?
Well, we get the notice. The letter was dated September 5th, so we need to respond by the 12th.
All right. So if you get me something on Monday or even today or tomorrow, just email the notice to me with a complete rundown of your contact information and the circumstances. And if you have a photograph of the grass that was too long, that would be great. Do I understand?
Well, see, the thing is, they apparently did this back in May, so I don't have a photograph of it then. But
did you own the home then?
Does it appear to you that these fines are a little excessive to charge $600 for grass? I mean, I wasn't even given any notification of this, and this was just 6 days after we purchased the property.
You know,
so
here's the thing. I'm not going to charge you for what I'm going to tell you once I get the information, because if I did, I'd be charging you way more than you're going to pay just to pay the fine. All right. I'm doing it out of what we call professional courtesy, to provide you some information to the extent that I can. I don't know if it's excessive, but I'm thinking that if you think that's excessive, you need to go to the ballot box and vote whoever out past that, or vote in somebody who's going to change that. There's probably a way to approach this where maybe you can resolve it. And I'm going to give you some information in the name of a man to call who might be able to help you out. The problem that you've got is that you're going to end up spending more on lawyer fees than you will just by paying it. And this is what I talk about when I talk about the economics of the law practice. You may have a completely perfect legal right to pursue somebody for money that they owe you. But if it's going to cost you $10,000 to collect $1,000, it doesn't really make sense, does it?
No.
Right. And so that's sort of the spot that you're in. But let me offer you this invitation. Send me your information. Get it to me today, and I'll get back with you by Monday.
Thanks. What's your email?
It's questions@thelawshow.com.
Okay. Thank you very much.
Thanks for calling The Law Show. We're going to continue answering all your legal questions at 855-529-7469. We're going to talk to John now. John, you're on The Law Show.
Yes, sir. This concerns two Illinois not-for-profit corporations.
Okay.
Corporation A sold real estate to Corporation B.
Okay.
3 weeks before the sale, the president of A personally loaned the president of B about $10,000 on a loan that we didn't know anything about. We don't know if it was personally or to the Corporation B.
Okay.
That loan has gone sour.
What does that mean?
The president of A now wants Corporation A to reimburse him for that $10,000 loan that went sour. I'm a shareholder of A, and I don't think it's right. Is there any legal grounds to stand on?
Well, there may be, but it all depends upon the operating agreement that the corporation is based upon. And so, if I could take a look at that operating agreement, or the bylaws and the rules that have been set up in that corporation, and cross-check that with the law in Illinois in relation to nonprofit corporations. That's what you said they are, right?
Yes.
It's a 501c3.
I don't know. It was set up about 50 years ago.
All right. It seems a little hinky to me. I don't know why the president of Corporation A would be able to recover the money. If he loaned it personally, that's not a corporate debt. But you know what? Time will tell, and the information will be contained within the documentation that you send me. So drop me an email and describe all the circumstances, and I'll get back with you as soon as I can, okay?
I certainly will. Questions at?
thelawshow.com.
Thank you.
Thank you. We're going to continue answering all your legal questions at 855-LAW-SHOW right after these few short messages. So stay tuned. If you're on the line and we don't get to your question by the time we go off the air on WLS, hang on. It's the Law Show Extra. We'll continue. I'm Brian Dailey, and I'm broadcasting live from High Top Law Show Studios in the Windy City, Chicago. It's the Law Show. We'll be right back.